Okay, I am just getting the streaming started, and then we will be good to get started. Okay, welcome to round two, everyone, and I will pass it over to Judge Bailey to get started.
Good afternoon, everybody. I hope we're all having a pleasant experience so far. My name is Jim Bailey. I want to do kind of a couple of admonishments before we get too far into the process. One is I want to make sure that both sides are ready for trial, that you've got everything put together. So if you can just pick somebody from your trial to answer that, yes, you're ready to proceed, that would be great.
Yes, Your Honor, we're all good to go.
Yes, Your Honor, the prosecution is ready to proceed.
The second thing I'm going to ask, which is for both my benefit and the benefit of others, is say your name before you speak. So if you walk up, you're a witness, tell us what your name is, tell us who the examining attorney is. We'll need some help with that. I suffer from a disorder that makes it so that I'm not good with names. And so I apologize in advance if I butcher your name.
Your Honor, can I interrupt? Sorry. Do you want the person's real name or like their character's name before we go up?
I'd prefer the real name. I'm assuming that the character name will come up during the course of their interrogation.
Thank you.
It sounds so formal as I say interrogation, though. We've already run through conflicts, so I'm going to go ahead and take a moment and swear. And I'm going to ask everyone to turn on your videos. And I know this is probably bad, but let's all swear. I want everyone to raise their right hands. I'm going to start with team members. Please raise your right hand. Do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
I do.
I do.
Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I'm assuming that we are limited and that there aren't any gallery members, teachers, or coaches that they're watching on the video. So I'm going to skip them. Scoring panelists, please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts and procedures?
I do.
Okay. Why don't you take a moment and introduce yourself and your team to the panelists, to me, and to the scoring judges.
On behalf of the prosecution, good morning, Your Honor, ladies and gentlemen, opposing counsel. My name is Kitty Wright, and today I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Avery Becker. Permission for my co-counsel to introduce themselves?
Yes, granted.
I'm Winter King, and I will be conducting the direct examination of Kyle Cusack, the cross-examination of Professor Blake Van Owen, and the closing statement for the prosecution team.
Thank you.
Good afternoon, Your Honor, ladies and gentlemen of the jury, opposing counsel. I am Anna Bensley, and I will be conducting the direct examination of Alex Cifuentes, the cross-examination of Taylor Perkins, and I will also be conducting the opening statement for the prosecution.
Thank you.
Your Honor, permission for our witnesses to introduce themselves?
Yes, I'd like that.
Good afternoon, Your Honor. My name is Ben Harriman, and I'm going to be portraying Jordan Markowitz.
Good evening, Your Honor. Today I'll be portraying the role of Kyle Cusack.
Good evening, Your Honor. My name is Kenzie Ferguson, and today I will be portraying the role of Alex Cifuentes.
Thank you. And for the defense?
Good afternoon, Your Honor. My name is Amanda Brockler, and along with my co-counsel, we represent the defendant Avery Becker in today's case. Today, I will be performing the closing examination for the defense, as well as the direct examination of Professor Van Owen and the cross-examination of Detective Markowitz.
Good afternoon, Your Honor. My name is Grant Rose, and today I'll be performing the direct examination of Taylor Perkins and the cross-examination of Alex Fuentes.
Good afternoon, Your Honor. My name is Jacob Aragon. Today I'll be giving the opening statement, as well as the direct examination of Avery Becker and the cross-examination of Kyle Kuzak. Your Honor, at this time, permission for the witnesses to introduce themselves.
Yes, please.
Good afternoon, Your Honor. My name is Amanda Jin, and I am Blake Van Owen.
Good afternoon, Your Honor. My name is Henna Patel, and I am Taylor Perkins.
Good afternoon. My name is Delaney Boston, and I'm Avery Becker.
Thank you. Are there, is the prosecution ready to proceed in this case?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
Are there any preliminary matters?
Yes, Your Honor. Your Honor, the prosecution requests permission to reserve time on closing for rebuttal.
If the permission is granted, I'm going to ask that you keep track of your own time, however.
Yes, Your Honor. The prosecution asked the same, my apologies. The prosecution also asked that exhibits be constructively published to the jury only after their admission.
Yeah, that's the rule.
And the prosecution also asked that in the event of technical difficulties, the time be stopped until the technical difficulties can be fixed.
I believe that's what your timers will be doing today. If they don't, I will come and I will admonish them to do so.
And we ask that the privileges be granted to the defense with the exception of time reserved for closing rebuttal.
They can speak for themselves with their own timer. I agree. Okay, let's get started. Does the defense have any preliminary matters?
No, Your Honor. I think the prosecution covered it all.
Okay, that sounds good. Let's get started then. Will the prosecution go ahead and open?
Good afternoon. Our actions prove the truth of our words. We are here to prove the defendant guilty of the actions of first-degree murder and second-degree burglary of a dwelling. The defendant says they are innocent of these crimes, yet as you will find, their words in association with their actions will be proof enough. Our story begins with Mr. Mackenzie Brackman. Mr. Brackman was a hard-working lawyer with a passion for training an upcoming generation of lawyers because Mr. Brackman was a high school mock trial coach. Mr. Brackman devoted lots of his precious time to settling the members of mock trial up for success at their competitions. Now, let's proceed to the reason we're here. On March 6th, 2020, Mr. Brackman was murdered. Mr. Brackman was starting his long weekend when he was surprised by an intruder breaking into his home. The intruder entered his home, likely unaware that Mr. Brackman was not at work that day, and engaged in physical combat, and then used a kitchen knife to murder Mr. Brackman. You may now be asking yourself why and who would lash out against Mr. Brackman in such a way. The prosecution also had these questions. First, it is important that you understand the actions taken by the defendant leading up to the day of the murder. As the defendant chose to ignore the guidance provided by Mr. Brackman and instead relying on their natural talent when preparing for mock trial competitions, disagreements between the defendant and Mr. Brackman were common. Mr. Brackman started out by punishing the defendant and removing the defendant from the A team before the important regional tournament, which the defendant was able to return to when their best friend, Taylor Perkins, a fellow senior, removed themselves from the A team as well. Then, sometime after the regional tournament, the defendant took their disagreements personally and vandalized Mr. Brackman's car, writing "Worst Attorney Award" in permanent marker. Today, the prosecution stands before the jury with the burden of proof. It is our duty to prove beyond reasonable doubt the existence of all the elements necessary to convict the defendant of both crimes. The elements of first-degree murder and second-degree burglary will be proven beyond a reasonable doubt through the witness testimonies and exhibits you will see today. especially the testimonies of the prosecution's 3 witnesses. Beginning with an expert witness, Kyle Cusack. Cusack has 19 years of experience as a certified crime scene reconstruction investigator. Mr. Cusack visited the scene after it was processed by other members of the crime lab and also reviewed the home security video footage and photographs taken of the crime scene. Ms. Cusack will describe her investigation methods that led to her concluding there had been a physical struggle and that the intruder indeed was the murderer of Mr. Brackman. You will then hear the testimony of Alex Cifuentes, a fellow mock trial team member of the defendants. Alex will recount to the jury how she exchanged text messages with the defendant prior to the murder of Mr. Brackman, where the defendant's words clearly expressed their intent to break into Mr. Brackman's home. The third witness will be expert Detective Markowitz. Detective Markowitz has been a homicide detective for the Denver Police Department for 7 years and has a certification in cell phone technology. Detective Markowitz's investigation included reviewing video footage taken of the intruder, who he will describe as matching the height and build of the defendant, as well as a use of his training in cell phones to show the whereabouts of the defendant's phone the day of the crime. In addition, based on pieces of indirect evidence, Detective Markowitz will show you how he came to his own conclusion that the defendant killed Mr. Brackman. The defense may try to paint the defendant as apologetic and willing to make amends with Mr. Brackman. However, Mr. Brackman chose not to engage further with the defendant. I implore you to ask yourself how any coach would rationally respond to a student who disrespected their property and person as the defendant had. When the prosecution puts together the pieces of this story, it will become apparent the defendant's words and actions were their undoing as they eventually brought them here, where they are charged with 2 serious crimes, 2 crimes that we will prove beyond reasonable doubt. Although the defendant may verbally deny the accusations, you will see the prosecution will show that their actions proved their words. Thank you.
Thank you very much. Does the defense have an opening at this time?
Yes, Your Honor. And before I begin, swearing panelists, Your Honor, is this a good view and can you hear me all right?
I can, and just please, again, make sure you introduce yourself so everyone has the chance to write down your name.
Absolutely. My name is Jacob Aragon, again for the defense, and I'll be giving the opening statement.
Go ahead, proceed when you're ready.
Avery Becker did not break into Mackenzie Brackman's home. Avery Becker did not kill Mackenzie Brackman. Avery Becker is not guilty. You see, Avery Becker was a former high school student. She had a passion for the law, and she was a decorated mock trial competitor. She is also a community member, a daughter, and a good friend. In fact, on March 6th, she spent her entire day with her friend, Taylor Perkins. They went to the mall, the Fry Shack, and home. They never spoke to Mackenzie Brackman. They never even talked to Mackenzie Brackman. And she certainly never did the things the prosecution wants you to believe that she did. Avery Becker now finds herself being a target in a criminal investigation. An investigation that was rushed, sloppy, and lacks any real evidence at all tying Avery Becker to the crime scene. Today, the prosecution is charging Avery Becker with 2 charges. They're charging her with burglary in the 2nd degree and murder in the 1st degree. Let me remind you, the prosecution has the burden in this case. They must prove to you each and every element beyond a reasonable doubt. It is the highest burden in our legal system. And as you see today, you will not be able to do that. If there's one element that you do not believe that they are not able to prove, then you must find Avery Becker not guilty. If you have any doubt in your mind at all, then you must find Avery Becker not guilty. The prosecution will not meet their burden in this case. Say the prosecution will leave you with 3 questions that go unanswered. 1, does the prosecution explain when this murder occurred? And as we will have to tell you, they can't and won't. 2, does the prosecution ignore other reasonable alternate suspects? And as we will have to tell you, they did. And 3, does the prosecution have any evidence at all tying Avery Becker to the scene of the murder. And as we will have to tell you again, they don't. You will hear from two prosecution investigators today. You'll hear from Detective Markowitz, the lead investigator on this case. And she will tell you this case begins and ends with Avery Becker. This was the first and only lead that he found. Next, you'll hear from investigator Kuzak, who reconstructs the crime scene. The prosecution has two detectives at the crime scene and no physical evidence at all to tie Avery Becker to the scene. This investigator does not collect DNA, fingerprints, blood samples, hair follicles, clothing fibers, or any other form of evidence that can connect anyone to this crime. So after not finding any DNA or fingerprints lead on the crime scene because they did not collect the evidence, the prosecution's next best option was to, of course, check out the high school mock trial team, the team that Coach Brackman coached for, to find possible suspects. The prosecution is asking you to take leaps, unreasonable leaps, to conclusions in this case that they do not have the facts to back up. Members of the jury, you should demand that the prosecution shows you each and every piece of evidence tying to Avery Becker to the scene of the crime, any evidence at all. That is their burden and their burden alone. They brought the charges today, and they have the responsibility of proving them. There are massive holes in this case. And members of the jury, you'll be able to see each and every one of those holes. This was a rushed investigation. This was a rush to judgment. Avery Becker is not guilty. Thank you.
Thank you. So let me ask a quick question of Allie so that she can help me. Should I be turning off my screen, or do you want me to just be lurking around the background? Feels rather odd being the only participant.
It's up to you if you'd like to turn your screen off, whichever you prefer.
Okay. Thank you.
No worries.
Does the prosecution want to then call its first witness?
Yes, Your Honor. I would like to call Kyle Kuzak to the stand.
Mr. Kuzak, will you please raise your right hand? Do you swear or affirm under the penalty of perjury that the testimony you're about to give will be true and accurate to the best of your abilities?
Yes, Your Honor.
Thank you so much. Let's proceed.
Thank you, Your Honor. Good afternoon. Please state your name and spell your last name for the record.
Kyle Kuzak, Kuzak.
What do you do for a living?
I am a Colorado Bureau of Investigation certified reconstruction investigator, also known as CSR, and I've spent my most recent 3 years with the tenure of Denver.
What is a crime scene reconstruction investigator specifically?
I investigate complex crime scenes and home invasions, burglaries, domestic violence, and things of that nature.
How long have you been doing your job?
I have 19 years of experience with this occupation.
Your Honor, move to qualify Kyle Kuzak as an expert in crime scene reconstruction investigation.
Is there any objection to that certification?
Yes, Your Honor, a brief voir dire, if that's okay.
Please.
All right. Just for clarification again, my name is Jacob Aragon. I'm doing the cross of Kyle Kuzak. Good afternoon, Ms. Kuzak, or is it Investigator Kuzak? I'm a little confused here.
It's Mrs. Kuzak.
Okay, but just to be clear, you're not a police investigator.
I am not, but I am a civilian employee of the police department.
And you never have been a police officer?
No.
So you've never gone to the police academy?
I have not, but I have a lot of other.
Never even responded to a call for service as a patrol officer?
No, I have not.
Never led an investigation as a lead detective?
No, I have not.
You don't have any specific training in forensic cell phone data analysis?
No, but I have a lot of experience and education in crime scene reconstruction investigation.
But you aren't certified as a forensic cell phone phone data analysis, correct?
No, but I am certified as a reconstruction investigator.
That's right. Your entire basis for what you claim is your expertise is your certificate of crime scene reconstruction.
Sorry, can you repeat that question?
Yes. So like you said, your entire basis for what you claim is your expertise is your certificate of crime scene reconstruction.
Yes, because that is a very important part of an investigation.
Which is based on what you claim are scientific principles and methods.
Yes.
Specifically, the 7-step methodology for event analysis.
Yes.
And you claim you reliably apply those principles and methods to the facts and data in this case.
Yes.
But how many steps did you follow in this case?
Counsel, I have a little concern here with these questions. You're moving beyond a voir dire or moving beyond a focus on the witness's qualification.
May I respond, Your Honor?
Of course.
Your Honor, you'll see with my point is that I'm proving that the type of investigation that she chose and the methods that she applied isn't regularly accepted by the scientific community, and that goes against Colorado Rule of Evidence 702.
I can understand that I would call it as you're approaching it as a Shrek motion, but at the moment we're not approaching this witness as a Shrek witness. The discrete issue that I'm at least hearing is this witness qualified to enter into this kind of testimony? I think you can make your Shrek case as you want to during the course of your cross-examination, and we can have a conversation at that time about that. But at this point, I do want to focus in on the precise question of, is this witness able to enter and to tender an opinion?
Okay, thank you, Your Honor. Your Honor, the defense objects. Oh, sorry.
Go ahead.
Okay, thank you. Your Honor, the defense objects to this witness being tendered in the field of crime scene reconstruction investigation. First, this witness lacks the requisite training and experience required under Rule 702. They have no formal training in any areas of crime scene investigation. And finally, their only basis of knowledge comes from a certificate in which they call crime scene reconstruction. Therefore, we object to her being tendered in the field.
Yeah. Is there a response?
Yes, Your Honor. Do I speak for the witness, or does the witness speak for themselves?
Well, there's a specific objection here that says your witness lacks some specific qualifications. Can you tell me what your qualifications are that underlie the introduction or the testimony that your witness is about to give?
Okay, so my witness has 19 years of experience in the occupation that they do, and they work with the Colorado Bureau of Investigation, and has spent 3 years of their tenure with the city of Denver. So I wouldn't understand why they wouldn't be qualified to speak on these topics.
Yeah, is there any reply?
Yes, Your Honor, this doesn't change the fact that this witness specifically doesn't have any training or any expertise in any other form when it comes to investigation. Like I mentioned in my voir dire, the only form of expertise or what they claim qualifies them is a certificate.
I'm going to go ahead and let the witness be certified as a crime scene reconstruction investigator, and she can tender expert testimony on that. I'm finding that the testimony of her experience is sufficient to tender her as an expert in this field, and I'll always remember the movie My Cousin Vinny for that precise point. So please proceed, Ms. King.
Thank you, Your Honor. What is your role in the investigation?
I investigated the scene of the crime after it was processed by other members of the crime lab, as well as reviewing police reports, photos, and the ring security videos.
What day was the crime being discussed?
Based on our investigations, the crime happened on March 6th, 2020.
Based on your investigation, what happened on the afternoon of March 6, 2020?
We believe on that afternoon that the intruder entered Mr. Brackman's residence and was then met by Mr. Brackman, who had grabbed a weapon to defend himself, and during the ensuing struggle was killed with the same weapon he introduced to the encounter.
So how did the suspect enter the home?
He first attempted to enter through the front door, but when that attempt failed, he went around through the back gate and entered through the back door of Mr. Brackman's home.
Did Mr. Brackman seem to allow the intruder to enter his home?
Objection, Your Honor, speculation.
Response?
I do not feel this is speculation, as the witness would just be testifying through their investigation whether or not it seemed that this entry was like authorized in the first place.
Any reply?
Yes, Your Honor. Again, the attorney, she's asking the witness if they are able to know if Mackenzie Brackman wanted to let the witness in or not. And since she is an expert in crime scene reconstruction investigation, that doesn't mean she knows the thoughts and mindset of Mackenzie Brackman.
Well, I'm actually going to permit the question because I think the question was, at least the way I heard the question, the call of the question was whether or not there was evidence or an indication that the entry was voluntary. But I am going to I'm going to ask Ms. King to re-ask the question, so to make sure that we get that precise answer and that we avoid any speculation.
Based on your investigation, did the entrance into the home by the suspect seem to be authorized by the victim?
Yes, the entrance did seem to be unauthorized, as Mr. Brackman had a ring security system, which would have allowed him to be notified to the presence of someone around his home.
What happened after the suspect entered Brackman's home?
We believe the intruder entered the home and was met by Mr. Brackman, who had grabbed a weapon to defend himself. And during the ensuing struggle, he was stabbed in the shoulder. And when he removed the knife from his shoulder, he then died.
Your Honor, permission for the witness to view Exhibit 8.
Just direct the witness to Exhibit 8.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 8.
Have you showed it to counsel for the defendant?
Yes, Your Honor, we have a copy of it.
Thank you.
Do you recognize Exhibit 8?
Yes, I do.
What is Exhibit 8?
It is a knife block that was found in the kitchen of Mr. Brackman's home.
How do you know?
This was the picture that I reviewed during my investigation.
Is Exhibit 8 a complete and accurate copy of the image that you reviewed during your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 8.
Objection?
No objections, Your Honor.
Exhibit 8 is admitted. You may publish it to the jury.
What do you notice about the block?
There seems to be a knife missing from the knife block.
What type of knife would fit in that spot?
Most likely a large chef's knife would fit in that spot.
Let the record reflect that I've stopped showing Exhibit 8. What type of knife did you find to be the murder weapon?
A large chef's knife as well.
Based on your investigation, how was the victim stabbed?
He was stabbed when the intruder got a hold of the weapon during the struggle, which caused the knife to nick the tip of his aorta. And when he removed the knife from his body, he would have started to bleed internally, causing him to die before he hit the ground.
Your Honor, permission for the witness to view Exhibit 18.
Permission granted.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 18.
Okay. Let me just make my own record for me. I want to make sure that the defense and the prosecution have shared copies of all exhibits in this case, whether electronically or otherwise. Is that an accurate expression? Mr. Aragon?
Yes, Your Honor, we have a copy of all the exhibits.
Okay. Yes, you can show the exhibit to the witness.
Do you recognize Exhibit 18?
Yes, I do.
What is Exhibit 18?
It is a photo of scuff marks that were found on the floor in Mr. Brackman's home.
How do you know?
This is a picture that was taken at the crime scene that I reviewed during my investigations.
Is Exhibit 18 a complete and accurate copy of the image that you reviewed during your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 18.
Objection?
No objections, Your Honor.
18 is admitted. You may publish it to the jury.
What do these scuff marks suggest?
These scuff marks suggest that there was indeed a struggle that occurred within the house, causing there to be marks on the floor.
Let the record reflect that I've stopped showing Exhibit 18. Your Honor, permission for the witness to view Exhibit 9.
You can simply, if you want to, so long as it's just the witness, you can just show witness Exhibit 9. Just identify what you're showing them, and then you can put it up on the screen. I don't think I need to give you permission for it.
Okay. Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 9. Do you recognize Exhibit 9?
Yes, I do.
What is Exhibit 9?
It is a plate that seems to have fallen and broken on the floor in Mr. Brackman's home.
How do you know?
This picture was taken at the scene of the crime, and I reviewed it in my investigations.
Is Exhibit 9 a complete and accurate copy of the image that you saw when you were investigating this crime?
Yes.
Your Honor, I move to admit Exhibit 9.
Objection?
No objections, Your Honor.
9 is admitted. You can publish it to the jury.
How do you think this plate broke?
We believe that during the struggle, one of the two, or possibly both, hit the table, causing the plate to fall on the ground, causing it to break.
Let the record reflect that I've stopped sharing Exhibit 9. Based on your investigation, was the home invasion planned?
We do believe the home invasion was planned. However, we do believe it was planned to be a home invasion, like burglary, and not a homicide.
How did the victim die based on your investigation?
He was stabbed in a bear hug-like fashion, it seems. And when the knife went into his shoulder, nicked his aorta, it was removed by the victim, and that caused him to bleed internally.
Thank you, Your Honor. No further questions.
Is there any cross-examination of this witness?
Yes, Your Honor.
Please proceed.
And before we begin, is it okay if I just ask for how much time is left, just to get a gauge? Awesome. Thank you so much. All right. Investigator Kuzak, before we tackle your opinions in this case, let's first be clear on what you did and did not do in this case. You claim that you conducted a thorough, comprehensive investigation.
Yes?
But you were not part of the initial investigation.
No, I was not.
You did not aid in the collection of evidence.
No.
You simply read the reports of the investigators.
Yes, that is what my job is.
But reading a report will never provide a person with the same degree of understanding as being on the scene or directly examining the evidence.
That's controversial, as someone being on the crime scene is seeing and capturing these images that I am seeing.
Detective Investigator, I am using your words here. So is that a yes?
Yes.
And after reviewing other people's reports, you came to only one possible conclusion.
Yes, I did.
That the victim must have been alerted by the Ring security system.
Yes, it would have most likely notified him that someone was at his residence.
Right, you claim the victim then looked for a defensive weapon.
Yes.
The victim then confronted the intruder.
Yes, after the intruder entered the house, he defended himself as anyone would.
And then stabbed the victim.
We believe during the ensuing struggle that the intruder did get a hold of that weapon and stabbed Mr. Brackman.
Let's talk now about the evidence, or rather lack of evidence, you base these conclusions on. First, you believe the Ring camera sent an alert to the victim's home.
Yeah, I do.
Yet you have no evidence to support this assumption.
I do not, but it is very unlikely that it would not have sent a notification to his cell phone.
Right, but a thorough and comprehensive investigation would have included obtaining records from the ring company.
Yes, but I did not find it necessary, as it would have notified him most likely.
Right, those records would have told you whether it had the ability to alert the homeowner.
Yes.
And a thorough and comprehensive investigation would have included a search of the victim's phone
Yes.
to determine whether the type of alert was even received.
Yes.
Neither of those things happened here.
No, they did not, because we did not find it necessary.
So that's a no.
That is a no.
Now on to your next conclusion. You believe that the victim had time to look for a weapon.
Not necessarily time. I mean, it's kind of an instinct. If you believe someone's breaking into your house, you'd want to do what you can to defend yourself.
Is your testimony today that the victim did not have time to look for a weapon?
No, my testimony is not that they did not have time to look for a weapon. It is unknown whether they grabbed it immediately or simply did not know.
Okay, well, this is based on your assumption that the victim was alerted by the ring camera.
Yes.
You indicate that the intruder took 10 seconds to go from the front door to the back door.
Yes.
And you believe it was 10 seconds based on the ring videos.
Yes, that's what the conclusions led me to believe.
But you've seen those ring videos,
Yes, I have.
so you know they don't contain a timestamp anywhere on them.
They do not, but that was our estimated guess.
So again, your conclusion about the timing is not based on any evidence at all.
No, it is based on my expert opinion.
And now onto your final assumption. To support your theory that the victim was aware that the intruder was about to enter, you rely on the scuff marks found at the scene.
Yes.
Specifically, the scuff marks found on the kitchen floor near the back door.
Yes.
But you have no way of knowing when those scuff marks were made.
Yes, but it is a possibility, because along with the broken plate, that is just two more reasons to lead us to believe that there was a struggle that occurred.
Right, but those scuff marks could have been made there an hour before the intruder arrived.
Yes, that is a possibility, but there's no definite way to tell when they were created.
Right, or even a whole day. Correct?
Correct, but it is more possible that they were created during the struggle.
But you have no evidence to support your assumption that these scuff marks are new.
No.
Even still, you believe these scuff marks indicate that at least 2 individuals were engaged in a struggle.
Yes.
Even though the evidence shows that the victim wasn't wearing any shoes.
Yes.
Thank you. No further questions, Your Honor. Is there any redirect of this witness?
No, Your Honor.
Okay, can this witness be excused?
Yes, Your Honor.
Okay. Does the prosecution want to call its next witness?
The prosecution would like to call Alex Cifuentes to the stand.
Good. Mr. Cifuentes, will you please raise your right hand? You swear or affirm under the penalty of perjury that the testimony you're about to give will be true and accurate to the best of your knowledge?
I do.
Thank you very much. You may proceed, counsel.
Okay. And just to clarify, my name is Anna Bensley.
I'm sorry. Thank you.
Okay, Ms. Cifuentes, please state your name and spell your last for the record.
My name is Alex Cifuentes, Sifuentes.
How do you know the defendant?
Avery and I know each other in a variety of different ways. She and I met through mock trial as well as school. We attended the same high school. Avery was the one who encouraged me to try out for mock trial. Because mock trial is such a large time commitment, we became very close friends on that basis.
What is mock trial?
Mock trial is a little bit hard to explain in detail, but to give a summary of the club, it is what it sounds like. We recreate trials, playing attorneys and witnesses, and it's just a really good experience, and I am super passionate about it.
Was the defendant talented at mock trial?
Mock trial is a large thing. There's a variety of areas to be talented in. So as far as preparation and work ethic go, Avery tended to be kind of subpar in those
Honor,
areas.
relevance.
there a response?
The witness is just laying foundation for relationships that they have perceived.
Okay, is there any reply?
Your Honor, this isn't laying any foundation for the relationships. This is simply talking about the aspects of the mock trial club, which have no relevance in this case today.
I'm actually going to overrule the objection. I think that the evidence goes towards the preliminary facts and it starts the process of the story. So I'm overruling it.
I will repeat my question. Ms. Fuentes, was the defendant talented at mock trial?
As I was saying, there's a variety of areas to be talented in. So with work ethic, preparation, Avery tended to be somewhat subpar in those areas, but Avery was also wonderful at improvising and making things up on the spot, which is also a huge part of mock trial.
Who is Mr. Brackman?
Mr. Brackman was a lot of things. Mr. Brackman was our mock trial coach and a defense attorney, but for me personally, he was an all-around great man who really cared about his students, and it's very hard now that he's gone and that it happened in such a horrible way.
What did you observe the relationship between the defendant and Mr. Brackman to be like?
Based off of what I saw, they had a horrible relationship. They fought pretty much every single mock trial practice, and it always seemed to me like they were incredibly frustrated with each other.
Are there any particular arguments that you remember?
They got into arguments all the time, but there's one that sticks out just because of how particularly horrible it was. It was right after our regional tournament. Mr. Brackman and Avery got in a fight again, just about the same old kind of things. And Avery, I guess, took it more personally and stormed off. And I saw her grab a permanent marker on her way out. And I believe from what I understood of the results of this, that Avery vandalized Mr. Brackman's car once she was out in the parking lot.
Did Mr. Brackman do anything in response to the vandalism?
I mean, of course he did. That's completely understandable. So he kicked Avery off of the mock trial team, which, as stated, is understandable. It's a horrible thing to do, vandalizing someone's car, but it put the team in a really tough position because we were headed to state, and under mock trial rules, you can't just substitute someone else in at the last minute.
Did you ever discuss this with the defendant?
I did. Avery actually reached out to me via text message asking if I would be willing to see if Mr. Brackman.
I'm sorry, can you restate your objection? I didn't hear it.
Hearsay, Your Honor.
Response?
This testimony would be excluded from hearsay under Rule 8031. Present sense impression, because Ms. Fuentes' statements are describing or explaining an event or condition immediately made while or after the declarant perceived it.
Is there a response?
Your Honor, this simply does not follow under this rule. The witness is discussing text messages, and that is not an immediate response to anything. We have not established any time when she saw these text messages, and therefore the prosecution cannot say that it was immediate.
I'm a little troubled, so I'm going to want a little bit more foundation before you go down this area of inquiry to lay a foundation for a present sense impression.
All right. Mr. Fuentes. We'll just continue with.
Bear with me one more second, and I apologize for interrupting you. What I'm worried about is the question of the immediacy. I think that Mr. DeRosa's objection, I don't remember hearing any foundation that would indicate it was a present sense or that it was an immediate event. So that's all I'm asking for foundation on.
All right. I would just like to skip that question, if that's all right.
No problem.
Okay.
The objection sustained then.
Your Honor, permission for the witness to view exhibit number 14.
Permission granted.
Let the record reflect that I am showing the witness what has previously been marked as exhibit 14. Do you recognize exhibit 14? Oh, sorry.
One moment. I'm not viewing Exhibit 14 as of right now. Okay,
My
there it
apologies.
is.
Okay.
Yes, I do recognize Exhibit 14.
What is Exhibit 14?
Exhibit 14 is the screenshot of the text message conversation that Avery Becker and I had.
How do you know this?
I mean, as stated, I was the recipient of these text messages and I also took these screenshots myself.
Is Exhibit 14 a complete and accurate copy of the screenshots and text messages?
Yes, it is.
Your Honor, I move to admit Exhibit 14.
Is there any objection?
Yes, Your Honor. I object to hearsay. We do not concede that these text messages came from the defendant, thus they do not, should not be admitted, and there hasn't been proper foundation to prove this.
Response?
This exhibit has been authenticated by the witness who would have knowledge pursuant, she has knowledge that they would, and claims that they are from the defendant.
Okay, any reply?
Your Honor, once again, my objection still stands. We do not concede that these text messages came from the defendant. There hasn't been proper foundation to prove that they came from Avery Becker.
Okay, I'm going to overrule the objection. The way that I'm viewing the text messages, the witness has testified that she is familiar with the sender of the text messages, and that would be consistent with it being from Ms. Becker. So the objection's overruled. You can proceed, counsel.
Mr. Fuentes, can you please read the last two messages you received from the defendant?
Would the presenter be able to scroll down? I cannot see the very last text message, I don't believe. If we could please continue.
Objection, Your Honor. This is cumulative as the document speaks for itself.
No, I appreciate that objection, and I know that we're short on time, but I believe that the prosecution can publish the exhibit in any manner they choose. So the objection's overruled.
Okay, I'm able to see the last two text messages now. The first is, I'm going to wait until he's at work, then break in and trash it, and then followed up by that'll show him.
Did you share this conversation with anyone?
Only Detective Markowitz.
Mr. Fuentes, did you fake these text messages?
Absolutely not, I would never do that.
Let the record reflect that I have stopped sharing Exhibit 14. Do you have any other connections to this case besides the screenshots?
I mean, as I testified to earlier, I saw the interactions between Avery and Mr. Brackman on a regular basis, so I can testify pretty clearly to their relationship, and I was also close friends with Avery, so.
Thank you, Your Honor. No further questions.
Is there any cross-examination of this witness?
Yes, Your Honor.
Please proceed.
Good afternoon, Ms. Fuentes. Before we talk about your time on the mock trial team, I want to understand your relationship with Avery Becker a little bit better. According to you, you and Ms. Becker had a very close relationship.
Yes.
You have always been really good.
You cut out at the last part of that question, so could you please restate it?
You have always been really good friends.
Yes.
Best friends, in fact.
I mean, we were close. I would definitely define it as that.
But you only really spent time together at mock trial practice.
I mean, as I said earlier, mock trial is a huge time commitment. So, well, yes, that is true. We were mostly there. It's because that's such a huge time commitment. We were both involved.
That's a yes.
Yes.
Even though you claim to be Avery's best friend, you would ask Coach Brackman on several occasions why he put up with Avery's attitude.
I mean, Avery was my best friend, but also I really appreciated Mr. Brackman, and I didn't always appreciate the way that Avery treated him.
So that's a yes then?
Yes, I didn't always side with Avery on everything. Best friends don't typically.
Well, whatever the relationship was, Avery Becker oftentimes got under your skin.
I mean, at times there's always things about your best friend that irritate you.
For example, you took your role in mock trial very seriously.
Yes, as previously stated, I'm extremely passionate about mock trial.
You would create outlines and multiple drafts of examinations, making sure they were perfect.
Yeah.
You would spend so much time honing your craft that it irked you when Miss Becker would come in and just make things up.
I mean, it's always frustrating when you spend a lot of time on something and then someone just comes in and is making it up and is doing as well as you are.
That's a yes then?
Yeah, somewhat annoying.
Oh, I'm sorry.
Please
And
continue.
the award?
I'm sorry you cut out. Could you repeat that question?
And she got the Best Attorney Award.
Yes, she did.
You feel that it is a slap in the face when somebody who doesn't work hard still gets the Best Attorney Award.
Yes, but that wasn't necessarily in specific reference to Avery. It's just in general talking about people who don't work as hard as you do.
Right, especially because you feel you were equally skilled as team members.
In our respective areas, yes.
So you were glad when Avery Becker was kicked off the team.
I wouldn't say I was glad. I would say that in a way it helped the team out, but also, as previously stated, it probably meant that we were going to have to forfeit going to state.
So you were excited about the larger role you would have with Avery gone?
I mean, yes, but Avery was a year older than me, so I would be getting those roles the upcoming year anyway, and I knew that.
And it works out better for you if Avery never gets put back on the team.
I wouldn't say that at all, necessarily.
Well, you think the team is better off without Avery.
In a way, Avery's being unprepared was sometimes really hard on the team.
So that's a yes.
I guess you could say that.
I'm using your words here. Speaking of being kicked off the team, let's talk about the next conversation you claim to have had with Avery Becker. You claim that Avery Becker texted you that she had planned to go to Coach Brackman's house and trash the place.
Avery first asked me if I'd be willing to go and talk to Mr. Brackman, and then when I said that I didn't think he would be willing to let her back on the team, then I received those text messages that you are referring to.
Yet you never contacted the police after receiving these alleged text messages.
No, I didn't, and in hindsight, I really regret that decision, and I think I'm going to regret it for a very long time.
But you agree what she texted you was an act that could have potentially put Coach Brackman in danger.
I mean, Avery was my best friend. I didn't want to think that she could ever go through something like that, and so I just really didn't want to believe that that was true. I was hoping that it was just an exaggeration of her anger.
You would have never done anything that would have put him in danger, correct?
No, of course not. I loved Mr. Brackman.
Yet the very first time you reported those text messages to law enforcement was after Coach Brackman was murdered, correct?
Yes, there was no way for me to know from those text messages that Avery was going to kill Mr. Brackman.
And only after Detective Markowitz reached out to you.
Yes.
Essentially ensuring that Avery Becker would never get back on the mock trial team.
I'm sorry, I don't understand how that question connects to the previous one.
It would essentially ensure that Avery Becker would never get back on the mock trial team.
I'm still confused on your question. What is it in your question?
Well, you reported those text messages after Coach Brackman was murdered, essentially ensuring that Avery Becker would never get back on the mock trial team.
Well, I mean, Mr. Brackman was killed at this point, so I don't really understand how that...
No further questions, Your Honor. Thank you.
Is there any redirect of this witness?
No, Your Honor.
Okay. Can this witness be excused? Yes.
Yes.
This witness can be excused. Are there any further witnesses for the prosecution?
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand. And before my direct, I would like to ask for a time check. Thank you.
Okay, do me a quick favor. I just want to remind people to try to say your name before you talk. Just to introduce yourself to the audience.
My name is Kitty Wright.
Okay, you can proceed, Ms. Wright.
Please state your name and spell your last for the record.
My name is Jordan Markowitz, Markowitz.
What do you do for a living?
I work for the Denver Police Department. I've worked here for 13 years and I've been a detective for 7.
Do you have any specialized training?
Yes, I have specialized training in cell phone technology as well as forensic data recovery.
What did that training involve?
That training involved learning how to acquire different types of cell phone data, how to use systems such as the Celebrite system to download data, and to get these certifications, I had to complete a training course as well as pass a certification test.
How many cases have you used your knowledge of cell phones on?
I use my training constantly as a detective. I've downloaded the contents of literally hundreds of cell phones, and I have used my knowledge. I mean, yeah, I've used my knowledge in over 50 cases.
Your Honor, at this time, the prosecution moves to tenor Detective Jordan Markowitz as an expert in cell phone technology.
Is there any objection?
Just a brief one, dear Your Honor.
Please.
Good afternoon, Detective Markowitz. I just have a few quick questions for you. You have a lot of training and education in the field of cell phone data and analysis.
Yes.
And you certainly have experience as a homicide detective.
Yes.
But fair to say you're not an expert in blood spatter analysis?
Not an expert, but I've seen a lot of cases. I've seen these things. So while I'm not an expert, I am experienced. I would say that I'm experienced.
You're also not a forensic scientist?
No, I am not.
You don't test DNA?
No.
Or analyze the results?
No.
In fact, you have no medical training at all.
No, why would I have medical training?
That's right. Your area of expertise is really just around these historic cell phone data.
Yes.
Judge, the defense does not object to this witness being accepted as an expert in the field of historic cell phone data and analysis, but we just want to make sure that their expert testimony is limited to just the field and that they're not providing improper expert opinions in the area of DNA analysis, blood spatter analysis, and the like.
Well, we'll get to that bridge if they go down that path, and we can have that discussion then. But hearing no objection, I understood the tender to be limited to the cell phone analysis, and so therefore I will certify this witness. Please proceed.
Thank you. What relation do you have to this case?
In March 2020, I was assigned to investigate the death of Mackenzie Brackman.
At what point did you arrive on the scene?
After uniformed officers secured the scene, I responded at approximately 2:20 p.m.
What were your first impressions of the scene?
There was a lot of blood up in the victim's left shoulder area. There was a knife just in front of his body as well.
Did you at any point in time enter the house?
Yes, I did. I went around through the back and entered through there.
What did you notice upon inspection of the house?
Upon inspection, everything was in maybe a slight disarray, nothing serious, but there were several expensive items that weren't taken, and I thought that was kind of curious.
What do you know about the victim?
He was a criminal defense lawyer, and I had been crossed by him several times.
Did you recover any information from the scene?
Yes, I did. I recovered the victim's cell phone. I was then able to find out that he was a mock trial coach through numerous emails. And then after that, I simply contacted the school that he was coaching and got a list of contacts for the mock trial students.
After obtaining the list of contacts, which student did you contact first?
I contacted student Alex Cifuentes first.
What information did Ms. Cifuentes give you?
Ms. Cifuentes informed me of numerous texts between a student named Avery Becker and herself.
What did you do after learning this information?
After learning this information, I immediately contacted Alex Fuentes and arranged to have an interview put in place.
After talking to Cifuentes, did you contact anyone else?
Yes, I contacted Avery Becker.
Did you end up having a meeting with Avery Becker?
Unfortunately, no. I contacted them and asked for an interview, but right before the interview, their lawyer contacted me and said that the interview would be canceled. And
Objection, Your Honor, that's hearsay.
There a response to the objection?
Yes, Your Honor. This falls under exception 801D2. Any statement by Avery Becker is opposing party statement. Or my apologies, it's not by Avery Becker. Any statement by Avery Becker's attorney is opposing party statement.
Reply.
Your Honor, this isn't a statement by the defendant. It was a statement by her attorney, so it doesn't follow under that exception. And also, Avery Becker has the right to refuse an interview and have that not be held against her in the eyes of the jury.
Tell me what the question was again.
The question was, did you take any further action after hearing? I believe that the question was, did you end up having an interview with Avery Becker?
I'm concerned about this one. So I'm going to have you proceed with the question. I just break it down a little bit. I'm going to ask that Detective Markowitz, I think I've got that right as a detective, can just answer the question. Let's stay on task so we can see if we're going to approach a hearsay statement. If we're going to approach it, I want to make sure that we've got a sufficient foundation to deal with the objections themselves. And I'm actually going to ask Ms. Brochler to stay online with us so she can get her objection in quickly.
So would you like me to repeat the question? Your
Yes,
Honor?
please.
Did you end up having a meeting with Avery Becker?
No, I did not end up having a meeting with Avery Becker
Why was that?
because unfortunately, right before the meeting, their lawyer contacted me.
Objection,
and,
Your Honor. This is the hearsay part.
I hadn't finished.
No, the objection's timely.
Do you want me to respond, Your Honor?
I think we've already done that. Do you have something that you'd like to add?
It's just the same exception as before.
Your Honor, my response stays the same.
One is this. I agree that it falls within an exception to the hearsay rule because I would find that the attorney is authorized to make this expression. My difficulty here is this expression, I think, isn't admissible under kind of a Fifth Amendment or another privilege. I don't do enough defense work to know, but I think my answer is I'm going to exclude this precise answer. Objection is sustained.
Did the attorney provide you with any resources?
Yes, the attorney provided me with Avery Becker's cell phone number.
Detective Markowitz, what are call detail records?
So basically, when an interaction with a phone is placed, like you could say a call or a text message is placed or received, an interaction of this event is created and recorded. So yeah.
How are cell phone towers used to track a person's location?
Well, most of the
Objection,
time.
Your Honor. Leading. This assumes that the witness has already established that cell phone towers track a location.
Response?
Rephrase, Your Honor.
Okay.
Detective Markowitz, how do call detail records and cell towers relate to each other?
Well, like I was saying, when an interaction with a cell phone is created, a record of this event is created, and therefore we can see which phone connected to which tower. And usually a phone will connect to the nearest tower. This is not always the case, but most of the time it is the case. So therefore we can see the person's location.
Can I continue, Your Honor?
Yeah, please go forward.
What did the call detail record show for this case?
The call detail record showed that a student named Taylor Perkins was continually calling Avery Becker's phone, and the phone clearly, I mean, the calls were in such short duration that Becker could not have been picking up. And that's not shocking to me considering what she was doing at the time.
Your Honor, permission for the witness to view Exhibit 15.
Permission granted.
One moment, Your Honor. Detective Markowitz, do you recognize Exhibit 15?
Yes, I do.
What is it?
It is a map, a diagram, really, of the cell towers that Avery Becker's phone connected to,
How do you know what it is?
because it's a diagram that I created myself.
Is it a complete and accurate copy of the diagram you created based off of the call detail records?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 15.
Is there any objection?
No, Your Honor.
15 is admitted. You can publish it to the jury.
Detective Markowitz, what does this diagram show?
This diagram shows that between 12:45 and 12:50, Avery Becker was at home, and between 12:50 and 1 o'clock, she was on her way to Mr. Brackman's home, and between 1 and 1:17, she was at Mr. Brackman's home.
Let the record reflect that I have stopped sharing my screen. To summarize, what do the call detail records for this case prove?
Like I said, it proves that Avery Becker was at her home between 12:45 and 12:50. She left.
Objection, Your Honor, asked and answered.
A response?
This question is provided to summarize the very detailed call detail records for the effect of the listener.
Reply?
Your Honor, I think the key word here is summarize, meaning that Detective Markowitz has already stated his conclusions before. So this has been asked and answered.
Okay, I'm going to overrule the objection. I don't feel like the testimony is cumulative to the prior testimony. I think that the question that the witness is summarizing his prior testimony is fine. So you can proceed.
To summarize, what do the call detail records for this case prove?
The call detail records for this case prove that Avery Becker was at home from around 12:45 to 12:50. She was on her way to Brackman's house from around 12:50 to 1, and from 1 to 1:17, she was at Brackman's home.
Based on your experience, the evidence provided and your experience as a detective, what do you believe happened the day of the alleged murder?
Based on the evidence I was given to work with, I firmly believe that on March 6, 2020, Avery Becker went to Mr. Brackman's home with the intent to burglarize and vandalize, but on that day, Avery Becker became the killer.
Thank you, Your Honor. No further questions.
Is there any cross-examination?
Yes, Your Honor. Can I get a brief time update? Awesome. All right, good afternoon again, Detective Markowitz. As a detective, especially a lead detective, you know that it's important to do a thorough investigation.
Oh, of course it is.
To follow all appropriate leads.
Yes.
And to identify and collect all relevant evidence.
Yes.
So let's talk about what you did and did not do in your investigation. In this case, we know that the intruder tried entering through the front door.
Yes, that is correct.
But ended up entering through the back door.
Yes, because the front door was locked.
Yet you did not have those doors checked for fingerprints.
No, we didn't.
And you didn't have the doors swabbed for DNA.
Nope.
Speaking of DNA, you testified that you found blood drops in the dining area.
Yes.
And you would agree that if those blood drops did not belong to the victim, they would be extremely relevant in this case.
Yes, that is correct, but I can't really. Yeah, that is correct.
Yet, detective, you didn't have those tested for DNA either.
Well, I mean, like we established earlier, I'm no expert with this medical stuff, I can't really talk about this.
You can't even collect it. You didn't even collect the blood as evidence.
No, I didn't, because I'm not authorized to do so.
As the lead investigator, you're not authorized to collect the blood as evidence.
Well, I mean, I have certifications in cell phone technology, not in that.
You claim that you took photographs of this blood,
Yes.
but this jury won't get to see those.
No, unfortunately, they were corrupted, and they're not here today. That was a seriously unfortunate event, but it did happen.
Your Honor, I believe there was an objection to relevance.
And I'm sorry, I did not actually hear the objection. Ms. Wright, do you have an objection?
Yes, Your Honor, I am objecting to the relevance of this question.
Okay, response?
Your Honor, the evidence that the jury is not able to see because of the misconduct of the police department in this investigation is extremely relevant to this case.
Any reply?
This evidence was unfortunately lost and so cannot be provided for the jury, and it was not done with any malicious intent, so I don't understand why that evidence is being brought up today.
I'm going to find that the evidence is relevant in that it has some tendency to make a fact more or less likely in the case, and I'm interpreting it relatively broadly as we're approaching these issues. I understand the theme of the defense in this case, and I can see how this evidence moves that theme forward, so I'll admit it.
Detective Markowitz, you lost that evidence.
Unfortunately, yes, as I mentioned, we did lose the evidence.
That's not the only thing that was lost in this investigation. Let's talk about leads. As a detective, you should never try and take the case where you think it should go, right?
Yeah, I follow where the lead takes me.
Right. You follow the evidence and go where it takes you.
Yes.
Good police work requires you to follow up on all possible leads.
Yeah, that's definitely something I value.
And in this case, the evidence showed that the victim was a somewhat well-known criminal defense attorney.
Of course.
That fact made you worry that this murder could be the work of a disgruntled ex-client.
For a moment, but when I found the evidence about Avery
Detective,
Becker, it led me
You're
there.
welcome to elaborate on this on redirect. I'm just asking for a yes or no.
Well, I can't really answer that with a yes or no. I feel like I need to elaborate on it to give the jury the full story.
You worried that this murder could be the work of a disgruntled ex-client.
Yes, like I said, for a moment, I did worry that, but I followed where the evidence took me, and it simply didn't take me there.
And it was highly unlikely that the victim's mock trial activity had anything to do with it.
At first, but like I said, when I found out what Avery Becker had done, yeah, it was pretty obvious to me that she was
Detective, you did not look into the victim's former clients.
I think we did look into it. I just didn't mention in my affidavit because it was completely irrelevant.
Instead, what you did was contact the local high school to get the names of all the mock trial students the victim worked with.
Well, yes, like I said, I completely value following up on all possible leads, and that's what I did.
Even though that theory was highly unlikely.
At first, it was highly unlikely. After I looked into it, not so much.
Detective, how many students are on that mock trial team?
I don't know. I can't speak on that.
As an officer, you attended a police academy, correct?
Yes, that is correct.
And in that academy, they teach you report writing skills.
Yes.
That it's important to document everything.
Yeah.
Including what witnesses you spoke to.
Sorry, I think there's an objection.
I think there was too.
Ms. Wright, I didn't hear your objection. I apologize.
The objection was to relevance for the question about the time at the police academy and those following.
Mm-hmm.
Response?
Your Honor, I'm just establishing that this detective has gone to a police academy and has learned report writing skills. So he has the expertise and the knowledge to be able to write a full report. And I'm using this to show that he did not include any of this information in his affidavit.
Any reply?
I can't hear.
I'm sorry, Ms. Wright, I can't hear you. Yes, go ahead and use chat. And I don't know, I'm just for purposes of the record, Ms. Wright has written that she stands by her relevance objection surrounding the police academy and training questions. I am going to find that the evidence is relevant for a variety of reasons, and therefore will overrule the objection.
Detective, we've established that you learned report writing skills, that it's also important to document everything in your report, correct?
Yes.
Including what witnesses you spoke to
Yes.
and what those witnesses told you.
Yes.
This is important because, as you know, the district attorney relies on your report in determining what charges to bring.
Yeah.
You also know that defense attorneys, like myself, also rely upon those reports to prepare a case.
Yes.
So what you put in your report matters.
Of course it does.
And what you fail to include in your report also matters.
I don't know if I really failed to include everything. I'm pretty sure I included everything that was relevant.
We'll get to what you failed to report. Now, in this case, your report only mentions Alex Cifuentes, Avery Becker, Taylor Perkins as mock trial students.
Yes.
But you also spoke to two other students, Brandon Digby and Josiah Mitchell, and that's nowhere in your report.
Yes.
Now let's talk about other evidence you failed to collect and document. You never downloaded the text message data from Alex Cifuentes' phone.
I mean, I couldn't.
Yes or no, you did or did not download that text message data.
I didn't, but it was for a reason.
Yet you have training and experience in data recovery from cell phones.
I do, but I didn't download it because I didn't have the phone.
And you have the software to do this and the ability to get a warrant to use that software, correct?
Yes.
Let's talk about when this murder occurred, because the time of the murder is extremely important to the case. Isn't that right, detective?
Yes, that is correct.
Because the time of the murder is what makes the cell phone records relevant.
Yeah.
And it's the only thing that ties Avery Becker to this crime scene. The cell phone records are the only thing that tie Avery Becker to this crime scene. Yes, detective?
Yeah, sure.
Now, we know that the 911 call comes in first. What time does that occur?
I don't recall. Can you refresh my memory?
It's actually not in your report. Let's jump straight to the crime. When did this crime occur? When did the intruder break into the home?
Sorry, I'm thinking here. I think it was based on the CDRs around 1.
Detective, you don't know when this crime occurred, and it's not in your report.
It wasn't in my report, but I do have evidence that it occurred at 1 o'clock based on the call detail records that I retrieved.
You have evidence where Avery Becker was at 1 o'clock, but not when this murder occurred, correct?
Well, Avery Becker was the killer, so.
We don't know that based on your report. This time.
Yeah, I think time has expired. Is there any redirect?
Yes, Your Honor. And to clarify, can you hear me all right?
Yeah, you're coming through. It's just the microphone's a little lower. We're all here pretty boomy voiced. And so you're getting trampled on, but we're doing a good job. I can hear you fine.
Thank you, Your Honor. Detective Markowitz, did you pursue the lead that you felt was the most promising?
Of course.
Did you take into account any other leads?
I did, but I didn't pursue them because the lead that I found the best evidence with was the one that I pursued.
Thank you, Your Honor. No further redirect.
Okay, are there any further witnesses for the prosecution?
No, Your Honor. The prosecution rests its case in chief.
Okay, do we need to deal with anything in the break?
Your Honor, we're not allowed to make halftime motions in trial, even though I wish we were.
Well, my answer is going to be then the answer is no, we're not going to deal with anything in the break and move on. Does the defense want to call its first witness?
Yes, Your Honor, the defense calls Professor Van Owen to the stand. Your Honor, we might be making this a little complicated for you this round, but my name is Amanda and her name is also Amanda. So,
Well, I'm going to try to go with the last names and I'll try not to butcher them too bad. So Ms. Brouchler, and I'm sorry, the witness's last name is?
Jin.
Okay, and actually I'll call you in character. It'll make it easier than Amanda. Raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you're about to give will be true and accurate to the best of your knowledge and ability?
I do.
You may inquire, counsel.
good afternoon, Professor.
Good afternoon.
Please introduce yourself to the jury by telling us your name and spell your last name for the court reporter.
My name is Blake Van Owen, Van-O-W-E-N.
Before we get to know you a little bit better, Professor, let's find out why you are here today. What is your relation to this case?
I was hired by the defense to review the evidence and render an opinion as to how this crime occurred.
Before we get to your opinions, let's start by talking about your background. What do you do for a living?
I'm a professor, a private investigator, and I often testify as an expert witness in police procedures.
Tell us about your educational background.
I got my bachelor's degree in English in 2005 from the University of Colorado in Boulder, and about 10 years later, I got my master's degree in criminal justice from Ashford University.
That's a pretty big gap in between your bachelor's and master's degree. What did you do in between?
I became a police officer with the Aurora Police Department from 2005 to about 2006. And after I left APD, I worked in various other areas of law enforcement.
Give us some examples.
I worked as a school resource officer, a private security guard, and finally as a private investigator, which is what I do now.
You mentioned earlier that you're a professor. Tell us about that.
I currently teach a class on police procedures as an adjunct faculty member at the Community College of the Rockies. And for the past 5 years, I've also taught a course at CU Denver in police practices and social justice.
You also mentioned that you often testify as an expert witness. What areas do you testify as an expert in?
I've testified as an expert witness in the areas of use of force, false arrest, police practices, and forensic evidence techniques, as well as crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Are you compensated for your work as an expert witness?
Yes, of course. This is my career.
How much are your fees?
I charge about $225 an hour for my investigation work and research, and $450 an hour for my time spent testifying.
What courts have you testified in?
I've testified in the U.S. District Courts in the districts of Colorado, Kansas, and Arizona, as well as the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
How many times have you testified as an expert?
In over 100 cases, at least.
You mentioned before that you were hired by the defense team to render an opinion in this case. Were you able to do that?
Yes.
What did you rely upon in reaching your opinions?
I've reviewed the police reports, the autopsy reports, the crime scene reconstruction conducted by Kyle Cusack, as well as the cell tower reports and exhibits prepared by Detective Markowitz. And I've also conducted my own partial investigation into certain areas.
Are your opinions the products of reliable principles and methods?
Yes.
And did you reliably apply those principles and methods to the facts of this case?
Yes.
At this time, the defense moves to tender Professor Blake Van Owen as an expert in the field of crime scene investigation to include cell tower analysis and general police investigation tactics pursuant to Rule 702.
Is there any objection?
No, Your Honor.
Okay, the witness will be so certified. You may proceed.
Professor, let's turn now to your investigation. What conclusions did you draw from the evidence?
Well, I came to 3 conclusions. The first, this was not a burglary gone bad. This was a premeditated and intentional murder. The second, there was no evidence tying Avery Becker to this crime. And third, the police investigation was incomplete and therefore unreliable.
Let's talk about each of those conclusions, starting with the first. What led you to believe that this was not a burglary gone bad?
Well, one of the key pieces in Investigator Cusack's theory is that there was a struggle between the victim and the intruder based on the scuff marks found at the scene of the crime. And that's it. That is the only piece of evidence that Investigator Cusack provides for that claim.
What's the problem with that?
Well, we simply have no idea when those marks were made. They could have been there 2 days, 3 days ago. Heck, they could have even been there 6 months ago. We simply have no idea when or how those marks were made.
We have no idea if the scuffle was caused by a kerfuffle?
That's correct.
What else led you to the conclusion that this was a premeditated murder?
The murder weapon.
What about the murder weapon?
Well, the knife that was determined to be the murder weapon did not match the same brand or style from the otherwise orderly and same set of knives found in the knife block in the victim's kitchen. This leads me to believe that the intruder brought the knife with them, since it cannot be matched to any brand or style from the other knives in the victim's knife block.
If you believe the intruder brought their own knife, how do you believe the victim was stabbed?
Well, we know from the autopsy reports that the victim was stabbed at a downward angle. If the victim and the intruder had both been standing up next to each other, the intruder would have had to been fairly larger than the victim in order to achieve that downward stabbing angle. However, we know from the ring footage that the victim and the intruder were roughly the same size, so that theory does not stand. Instead, it's my opinion that the victim must have been sitting down and the intruder must have come up from behind the victim and stabbed the victim from behind.
How do you conclude that the intruder came up from behind the victim when we heard testimony that the victim was alerted by a ring app?
Well, the prosecution assumes that the victim was alerted to the intruder entering the home because of the Ring security system sending an alert to the victim's phone. However, we have no evidence that the victim even received such a notification. Personally, I have a Ring doorbell, and you can turn off notifications like that. Detective Markowitz has not put forth any evidence as to whether the victim had their notifications turned on, whether the victim even received such a notification, and frankly, whether the victim even had his phone on him at all.
So based on your investigation, the intruder brought their own weapon and came up behind the victim and stabbed them from behind, indicating what?
Exactly, indicating that this was a premeditated murder. The intruder entered the home for the purpose of killing the victim.
Moving on to your second issue with Detective Markowitz's investigation, you indicate that there is no conclusive evidence tying Avery Becker to the scene of this crime. How did the detective tie Avery Becker to the crime?
Detective Markowitz relied solely on the cell phone records of Avery Becker on March 6, 2020.
Is there a problem with that?
Yes, there are many problems with that.
Like what?
Well, first, it's important to understand that cell phone records show the possible location of a cell phone, not of a person. For example, if you left your phone in a cab and someone were to check those cell phone records for that night, it would simply show the location of the cab's route, and not you, because you were nowhere near your phone.
It's pretty rare for a teenager not to be with their phone 24/7, right?
Well, there was evidence presented to Detective Markowitz during his investigation that Avery Becker had lost her phone and did not have it the day of the murder.
Well, Detective Markowitz believed that Miss Becker had her phone, so following his assumption, why would this evidence still not be sufficient for you?
Well, it's also important to understand that cell tower data is not like GPS. It's not as accurate.
What do you mean?
Well, there are two reasons. One, cell towers can cover very large areas. Some can cover over 100 square miles. And two, cell phones are programmed to connect to the best tower for a connection, which isn't always the closest tower to that cell phone.
So how does this affect the reliability of Detective Markowitz's opinion?
Well, assuming that Avery Becker was with her phone on the day of the murder, which we have no evidence corroborating, just because her phone connected to a certain tower does not mean that she was in the vicinity of that tower. Detective Markowitz's opinion is based solely on assumptions.
Speaking of assumptions, you also mentioned that the police investigation was incomplete. Based on your expertise, what is this investigation lacking?
Well, how much time do we have?
Keep it brief, Professor.
Well, while we're on the topic of cell phones, Detective Markowitz should have obtained a search warrant to collect and search through Alex Cifuentes' phone.
Didn't the detective get information for Alex Cifuentes' phone?
Absolutely not. Detective Markowitz simply accepted a screenshot of the alleged text conversation between Avery Becker and Alex Cifuentes. Any reputable cell phone expert would know that this is unreliable.
What could the detective have done with a search of the phone?
Well, as law enforcement, there are programs we can use to do what we call a cell phone dump, which is basically downloading the context of a cell phone, including text messages. One of these programs is called Elbert, which Detective Markowitz has already admitted that he has access to.
In addition to the lack of investigation into Alex Cifuentes' phone, what else did you find missing from the investigation?
A complete lack of investigation into any other possible suspects.
Is there any evidence of another possible suspect?
Absolutely. Even from a cursory view of the evidence, already one name stood out to me as a credible possible suspect.
Who's that?
Blair Rollins.
Okay, so tell us who Blair Rollins is.
Blair Rollins is son of Jonathan Rollins.
And who's Jonathan Rollins?
Mackenzie Brackman was the defense attorney who represented Jonathan Rollins in trial. He had been accused of murder. At the trial, the jury found him guilty and sentenced Jonathan Rollins to life in prison.
How does this connect to Blair Rollins?
Blair Rollins was present in the courtroom during the hearing, and there's also an audio recording of the hearing that I personally listened to. After the sentencing, Jonathan Rollins yelled out that Brackman was going to die.
So what does this mean for your investigation?
This goes to show that Blair Rollins had a much stronger motive to want to kill Mackenzie Brackman, a much stronger, more serious motive than just wanting to get back on a mock trial team.
What other evidence, if any, also pointed to Blair Rollins?
Blair Rollins matches the same shape and build of the suspect in the ring video. Blair Rollins was also absent on the day of the murder and has no alibi for the time of the crime. Even more suspiciously, Blair Rollins essentially disappeared after graduation, and his whereabouts are unknown.
Yet despite all of that, did the police ever investigate Blair Rollins?
No, they failed to do so.
Thank you. No further questions.
Any cross-examination?
Yes, Your Honor.
Please proceed.
Let's begin with your analysis regarding the murder weapon. You believe that the suspect could have brought it onto the scene themselves?
That's correct.
So you do not believe that the victim could have pulled a knife from the knife drawer?
It could have been possible, but my evidence leads me to believe that the intruder brought the knife with them.
You believe that you could also have obtained the tower records for the day prior to the murder in order to confirm that Becker and Perkins had been at the same locations a day earlier, but you didn't do so?
No. I do believe that Detective Markowitz, who was the lead investigator in this case, should have done so.
To confirm you didn't do so?
That's correct.
You also believe that the victim turning off his ring notifications would make him unaware of a break-in?
No, I'm just saying that the prosecution didn't provide any evidence as to whether or not the victim had his notifications on.
No further questions, Your Honor.
Is there any redirect?
No, Your Honor.
Okay, will the defense call their next witness?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Ms. Perkins, will you raise your right hand? Do you swear or affirm under the penalty of perjury that the testimony you're about to give is true and accurate to the best of your ability?
I do.
Thank you. You may proceed, counsel.
Good afternoon, Ms. Perkins. Please get comfortable when you're ready. Tell us your name and spell your last name for the court reporter.
Taylor Perkins, Perkins.
You were on the mock trial team last year, correct?
Yes, I was.
What was your relationship like with Coach Brackman?
It was fine. We didn't really have any issues with each other, unlike Avery and Coach Brackman.
What do you mean by issues?
Well, even though Avery was the best lawyer on the team, Coach was always giving Avery a hard time about being unprepared sometimes and doing the least amount of work.
How did Miss Becker deal with Coach Brackman?
Avery's been known to play silly little pranks on Coach Brackman.
Give us an example of one.
Well, one time after regionals, Coach Brackman was getting mad at Avery about not being prepared again, and she wrote with what she thought was a dry erase marker on his car.
Objection, lack of personal knowledge.
Response, Mr. DeRose?
Your Honor, this is not lack of personal knowledge. The witness is a member of the mock trial team and was present and current at the day of the event and knows all of the information.
Okay, counsel, reply.
I do not believe that the witness was present at that event.
Mr. DeRose, do you mind giving me a little bit more foundation concerning where the witness was at the time of the event?
Yes, Your Honor. How did you know that that Avery went out to vandalize Coach Brackman's car?
Well, I wasn't on the team technically because I did step down, but that night Avery told me exactly what happened, and I did hear from the other members of the mock trial team.
And how did Coach Brackman appear to react to the vandalism?
Well, unfortunately, to me and Avery and the whole team's surprise, it turned out not to be a dry erase marker, but a permanent marker. So Avery ended up getting kicked off the team.
And how did Avery handle getting kicked off the team?
She tried to apologize to coach over and over again, and she felt really terrible about it all. And she was just really trying to get up back on the team.
Objection, Your Honor, lack of personal knowledge again.
Response?
Your Honor, this is not lack of personal knowledge. The witness has spoken to Avery and knows the events and the details of the team. And the witness is on the mock trial team. She would know if Avery Becker was able to get back on it or not.
Okay, reply.
I don't believe the witness can testify to actions that Avery took, such as apologizing to Mr. Brackman.
This is a close one. I'm going to go ahead and overrule the objection. I'm going to find that the witness has personal knowledge. I have some questions as to the underlying foundation, but let's move on.
And was Avery ever able to get back on the team?
No, she wasn't.
Let's fast forward a bit and talk about the day before Coach Brackman was killed on March 5th. Did you treat Avery Becker that day?
Yes, we were together basically the whole day.
And what did you two do?
Well, first Avery came over to my house, and then we went to the Fry Shack, then the mall, then back to my house.
Did you run into anybody that you knew at the Fry Shack?
Yes, we actually ran into the students from the mock trial team.
Who did you run into?
We ran into Alex Fuentes, and him and Avery spoke.
Did Avery and Alex get along?
No, not really. It always seemed like Alex was a little jealous of Avery's success on the team.
You mentioned that Alex and Avery spoke at the Fry Shack, though.
Yes, until Avery stormed off.
What do you mean stormed off?
Well, Alex was telling Avery how upset she was about Avery being kicked off the team, and it just came across as really insincere and a little passive aggressive. And obviously Avery got upset and she went into the bathroom.
Did Alex Fuentes stay at the table?
Yes, along with Avery's phone at the time.
And what did you do?
I didn't realize the phone was there, so I just went to grab Avery and then we left to go to the mall.
Did you go anywhere else that day?
No, just the mall, then back to my house.
Okay, let's turn now to the following day, March 6th. Where did you two go that morning?
Well, Avery came to pick me up at my house in the morning, but I told her how I kept calling her over and over again and she wasn't picking up. So we realized that her phone was missing. So we skipped school and spent the day retracing our steps to find the phone.
What do you mean by retracing your steps?
Well, we went to the Fry Shack and it wasn't there, and then the mall, and then all the stores that we went to that previous day, and we still couldn't find it.
To your knowledge, did Miss Becker ever find her phone that day?
No, we kept calling it over and over again and still couldn't find it.
Now, were you with Miss Becker the whole day on March 6th?
Yes.
And at any point on March 6th, did you or Miss Becker go to 444 South Flower Street?
No, we were nowhere near there.
And at any point on March 6th, did you or Miss Becker come into contact with Coach Brackman?
Not at all.
No further questions, Your Honor. Thank you. At this time.
Cross-examination.
Yes, Your Honor. The defendant, Avery Becker, is your best friend?
Yes.
Avery is the reason you were on mock trial?
Yes.
Avery was talented at mock trial?
Yes.
You think Avery was the best attorney on the mock trial team?
Yes, she won the most awards.
Relevance.
I'm sorry, was there an objection?
Yes, Your Honor. My objection was to relevance.
Counsel? Response?
Sorry. I'm just having the witness lay some foundation as to their relationship with the defendant and what they know of the defendant.
Reply.
Your Honor, whether or not Avery Becker was good at mock trial has nothing to do with their relationship. So my objection stands.
Yeah, I appreciate the objection. I'm going to find that it goes to a preliminary matter. we're laying some underlying foundation that's relevant to the story. So I overruled the objection.
I will restate the question. You think Avery was the best attorney on the mock trial team?
Yes, I do.
You stepped down from the mock trial team so Avery could have their spot back on the A team?
Yeah, she definitely didn't deserve to get kicked off the team, and I knew that we weren't going to win without her either way.
Even though you were a senior who had also been on the team for 4 years?
Mock trial didn't really mean that much to me. I mean, I don't want to be a lawyer, unlike Avery.
Avery vandalized Coach Brackman's car,
Yes.
as you phrased it, to let off some steam and freak Coach Brackman out.
That was her original intent, and she realized that she went too far, and she didn't realize that it was a permanent marker, so it just went out of control.
Let's talk about March 5th. March 5th was the day that Avery lost her phone.
Yes.
Avery uses her phone a lot.
Yes.
Avery uses her phone so much you call it her third kidney.
Yes, I think a lot of teenagers' phones are like a third kidney.
You and Avery went to the Fry Shack together on March 5th.
Yes.
After leaving the Fry Shack, you and Avery spent time at the mall.
Yes.
Avery didn't use her phone at all after you left the Fry Shack?
No, we were together, so there was really no reason to use a phone.
Now let's discuss March 6th. The morning of March 6th, Avery picked you up for school.
Yes.
Avery hadn't answered your text or calls that morning?
No.
So you texted Avery that morning, but since they didn't answer your text, you weren't sure Avery was taking you to school?
I mean, she always took me to school those mornings, especially when we had first period off like that day, so I just assumed that she was going to come.
Did you not consider contacting Avery in any other way?
I mean, I texted her. That's really all I could do at the time. I don't really know how else to contact her.
Avery noticed her phone was missing when you brought it up.
Yes.
You think Avery may have left her phone at Fry Shack?
Yes, definitely.
You did not consider using the Find My iPhone program to find Avery's phone?
I mean, I have an Android, so I didn't realize that we could use the Find My iPhone utility.
I would just like to clarify some facts from your witness statement. You talked to You talked about Mr. Brackman's murder with Avery?
Well, I mean, we talked about, like, as a team, we talked about it. The entire school was talking about it.
But did you talk about it with Avery?
Yes, she's my best friend. We talk about everything together, and this was a pretty terrifying thing to happen, so we were talking about it, yes.
And you stated your story matches Avery's?
I mean, it's the truth. I don't know if it matches, but I'm just telling my truth.
But did you state that your story matches?
I mean, I'm sure it does. We were together all day. So it matches with a lot of people's, I'm assuming.
No further questions, Your Honor.
Is there any redirect?
No, Your Honor.
Okay. Does the defense want to call their next witness?
Yes, Your Honor. The defense calls Avery Becker to the stand. And just for clarification, you already know me, I'm Jacob Aragon, but this is Delaney Boston playing Avery Becker.
Thank you. Ms. Becker, will you raise your right hand? You like the way mine keeps coming in and out of the screen. I like that. Do you state or affirm under the penalty of perjury that the testimony you're about to give will be true and accurate to the best of your knowledge and abilities?
Yes.
Okay. Counsel, you can proceed.
Awesome, thank you. Good evening, Ms. Becker.
Good evening.
Tell us your first and last name and spell your last name.
My name is Avery Becker, Becker.
Before we get into the details of this case, let's address the question on everyone's mind. Did you break into Mackenzie Brackman's home?
No.
Did you ever physically assault Mackenzie Brackman?
No.
Ms. Becker, did you kill Mackenzie Brackman?
Absolutely not.
Now that we've gotten that out of the way, let's learn more about your relationship with Coach Brackman. How do you know Mackenzie Brackman?
I went to Colorado High School, and he was my mock trial coach for the last 4 years.
What was your relationship like?
It wasn't always easygoing. I mean, we had our disagreements. He thought I didn't work hard enough, and I disagreed with that.
Were you always at each other's throats?
Not always. I gained a lot from mock trial, and it was a really wonderful experience.
Did you hate Coach Brackman?
I wouldn't say hate. I don't think he liked me very much, but I didn't hate him, and I just can't believe he's gone.
Now, you mentioned disagreements. Do these ever come to a head? I'm sorry, did you hear me, Ms. Becker?
I would say they probably came to a head about right after yes, I would say that it really kind of came to a head about a month after the regional mock trial tournament.
What happened?
Well, I had won best attorney, and I also got an award for closing, but to do that, I had to go off of script, and I did that by pretty much not doing what he wanted me to do during trial.
How did Coach Brackman handle that?
Well, he really laid into me about how I didn't deserve the awards that I got, that I didn't work hard enough. But what bothered me most was that he said I only relied on my good looks.
Objection, Your Honor, hearsay.
Response?
Your Honor, this is not hearsay. It's not being offered for the truth to prove that Ms. Becker did not deserve the Best Attorney Award, but rather to show this effect the statement had on Ms. Becker and why she ultimately vandalized Mr. Brackman's car in the end.
Reply? I didn't hear anything from Ms. Wright, so I'll assume that she's just going to stand on her objection. Okay. I'm going to overrule the objection and permit the testimony. I think it's a close call. I do have some relevance questions that underlie it as well. Proceed, counsel.
Thank you, Your Honor. How did Coach Brackman handle that?
Well, he really laid into me after the regional mock trial tournament. I worked hard enough, but what bothered me most.
I'm sorry, Ms. Becker. Do you mind just repeating? I didn't hear the last part. What bothered you the most?
It really bothered me the most that he said that I only relied on my good looks.
Why did that bother you the most?
Well, it was just a really uncomfortable comment that an adult male made about a female student like myself, and it was just unwelcomed, and it made me feel bad.
How did you handle that, having your coach tell you these things?
Well, I was really upset, angry even, and so I stormed out of practice because I was tired of being insulted.
What happened when you left?
When I left, I went to the parking lot and I seen his car, and I still had a dry erase marker in my hand from practice. And so I wrote on the hood of his car, Worst Attorney Award. Come to find out, it was actually a I've ever done in my life.
I'm sorry, again, the last part was a little confusing. Just for clarification for the judge and the members of the jury, you said that you found out it was a permanent marker?
Yes, after I had written on his car, I realized it was a permanent marker, and it was the stupidest thing I ever have done.
How did Coach Brackman find out about his car?
Well, when I had turned around after I was done writing, he was right behind me and he just exploded.
What do you mean by exploded?
Well, he was yelling at me and he was just really upset.
What did he say?
He said, "What the hell have you done to my car? That's it, you're kicked off of the mock."
Objection, Your Honor, hearsay.
Response?
Your Honor, this is hearsay. However, it falls under the exception of excited utterance rule, which is Colorado Rules of Evidence 8032.
Reply? I'm just looking up the rule here a bit. I think again that the issue here is going to relate to the foundation that's been laid for the a potential excited utterance. I'm going to permit the question, assuming that a sufficient foundation will be forthcoming, and I will overrule the objection.
All right. So would you, just for clarification, would you like me to lay more foundation, or would you like me to continue with this question?
I think you can continue with the question.
Perfect. Thank you so much, Your Honor. What did he say?
Well, he said, "What the hell have you done to my car? That's it. You're kicked off of the mock trial team."
How did you respond?
Well, I was really, really upset. Mock trial means so much to me. And I just went home to my mom and cried and cried.
Did talking to your mom help?
It definitely did. It provided me kind of some clarity. And so I decided to go the next morning to his office to apologize.
How did he take your apology?
Well, when I got there, his
Objection, Your Honor, speculation.
Response?
Your Honor, you'll see with the witness's answer that, in fact, Coach Brackman didn't actually answer her at any point, so there really is no speculation with this, as you'll see with her answer.
Well, tell me what the precise question was.
So the question is, how did he take your apology? And then I anticipate the witness will talk about how Coach Brackman inevitably never did take her apology.
I'm going to ask that you rephrase the question, because I too heard it in the same way that Ms. Wright heard it, which was you were requesting for information about what the coach's state of mind was, or his opinion, how he took it. If you can just use a different word, we can move forward.
Yeah, absolutely. Did he ever take your apology?
Well, when I got to his office that morning, the front office person said that he was busy. So then I tried to text him saying how I would pay to repaint his car, that I would scrub it.
And did Coach Brackman ever respond?
No, he didn't respond to my texts, and I was devastated.
Why were you devastated?
Because I never got the chance to apologize before he was killed.
Well, speaking of the murder of Coach Brackman, let's talk about your whereabouts that day. Where were you on March 6th?
I was with my friend Taylor Perkins the entire day.
What did you and Miss Perkins do all day?
Well, that morning I had realized that I didn't have my phone, so we decided to skip school and look for it.
How did you look for it?
We retraced our steps, so we went to the Fry Shack, we went to the mall, we tried calling it, but it would just go straight to voicemail.
Did you at any point go to Coach Brackman's house on March 6th?
Not to my knowledge. I don't even know where he lives, and also I was preoccupied looking for my phone the whole day.
Ms. Becker, you've been sitting here throughout the entire trial, and you've heard testimony from all the witnesses. Now, one of those witnesses, Alex Cifuentes, is claiming that you texted them that you plan to go to Coach Brackman's house to trash it. Did that happen?
I never sent any of those texts, none of them.
Did you want to get back at Coach Brackman?
Initially, I think I said something like that to my mom, but I was meaning that more of like embarrass him or like prank him or something, but even those feelings change.
What do you mean those feelings changed?
Well, my number one priority was getting back on the mock trial team. Mock trial meant everything to me, and getting back into Coach Brackman's good graces was the only way to get back on the team, and I wouldn't do anything to jeopardize that.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Let's start with your relationship with Mr. Mackenzie Brackman. You say that from the beginning he would frequently tear you down.
Yes.
Claiming that you were lazy and you didn't put in the work.
Yes.
Naturally, this upset you, correct?
Yes.
Enough for you to damage his property?
Yes.
Let's talk about the night of the car incident. Mr. Brackman came in and immediately started telling you in front of everyone that you didn't deserve the award you won during the competition.
Correct. It was horrible.
He came in right before you were about to write on the whiteboard, so when you left, you still had the marker in your hand.
I did.
Unfortunately, after vandalizing Mr. Brackman's car, you discovered that your whiteboard marker was actually a permanent marker.
I did.
Were you planning on using a permanent marker on the whiteboard?
I still had the dry erase marker in my hand. I thought it was a dry erase marker.
But it ended up being a permanent marker that you were planning on using on the whiteboard.
I was planning on using a dry erase marker on the whiteboard, but I just had it in my hand, so that's why I thought it was a dry erase marker when I went out.
So after that, he kicked you off the team.
Yes.
You claim that you made several attempts to apologize, but he never took the time to hear your apology, let alone give any response.
I really tried to apologize, and I really wish I could have.
Did this make you feel upset at him?
I was just sad, and I was disappointed in myself that I even did this. I was disappointed that I couldn't reach him to be able to apologize.
Finally, let's talk about your phone. Can you tell me the last time you recall having your phone?
Last time I recall was probably at the Fry Shack the day before.
So
the day
throughout
before.
that entire evening, you did not notice that you did not have your phone on you?
No, I didn't.
It took you until the next morning to realize you had not had your phone on you.
Well, I was extremely tired that night, so I didn't notice.
So you skipped school to find it with your friend Taylor Perkins.
I did.
Did you use resources to find your phone?
Did I what?
Did you use any resources to find your phone?
Yeah, we used Taylor Perkins' phone to try to call it. And it just kept going straight to voicemail, and it just kept going straight to voicemail. And so we were trying again and again. We also went back and retraced our steps. And so we were looking around, but that's we tried really hard to find it.
So you didn't use any resources such as iCloud or Find My iPhone or other apps such like that?
We did use resources. We called using her phone. I didn't use iCloud or whatever you're talking about, but we used the resources like her phone.
So you were looking for your phone using no tools except your memory of where you had been that night?
Like I said, we were using the resources of calling it from her phone. We retraced our steps. We were walking around the mall. We were looking everywhere for it.
Did you ever find your phone?
I think I did.
You did find your phone.
But I don't remember. I probably like months later, I don't know, weeks. I don't really remember. It was a long time ago.
No further questions, Your Honor.
Any redirect?
No questions, Your Honor. Thank you.
Does the defense have further witnesses?
No, Your Honor, the defense rests.
Okay, is everybody ready to close?
Yes, Your Honor.
Yes, Your Honor.
For the people? Go ahead, proceed, counsel.
Our actions prove the truth of our words. Today, you have seen arguments from two sides of the courtroom, one stating that there is a clear suspect and another that disagrees. May I remind the jury that the burden of proof for this case is one that is beyond a reasonable doubt. This means that in order to find a defendant guilty, you cannot have any reasonable doubt in your mind whatsoever. You must believe that the defendant is truly guilty. For this trial, there are two charges being placed upon the defendant if she is found guilty. The first being first-degree murder. The requirements to be met for this charge include committing or even attempting second-degree burglary, and someone dying at the hands of the person found guilty. For the charge of second-degree burglary, this includes knowingly breaking into a dwelling, which in this case is the victim's home. The intent of this can be seen with Exhibit 14, which is screenshots between Cifuentes and the defendant. Cifuentes was a friend of Avery's who came to testify. These screenshots entail the defendant planning to trash the victim's house while he was at work. These screenshots being testified as authentic by Cifuentes, there is no doubt that there is intent within the defendant's words. This intent being the action of attempted burglary. This truly shows that our actions prove the truth of our words. The defendant planned to break into her coach's house to seek revenge. And it was the defendant who committed this crime that very afternoon. Becker had a motive. The relationship between the two had been strained. This would leave Becker to seek revenge by trashing his house while he was away. As the victim heard the intruder attempting to enter the dwelling, he grabbed a knife from within his kitchen for his own safety, whether it be from the knife block with the convenient space left within or the drawer full of assorted knives. This then led to conflict within the home, shown with many different exhibits, such as a broken plate and scuff marks on the floor. Cell tower records show that the defendant was close to the scene of the crime at the time of the murder. Becker also claims that her phone was slow and getting old, so she turned it in conveniently after the crime occurred. This would be ironic for someone whose phone is their second kidney. I would like to remind the jury that this is a case of murder in the first degree, something that must be dealt with in the correct manner and swiftly. Someone's life has been lost due to the actions of the defendant, and the appropriate actions must be taken in order to find justice. I ask the jury to find the defendant guilty of murder in the first degree, as well as second-degree burglary. The defendant's actions truly prove the truth of her words. Thank you, Your Honor.
Thank you. Does the defense have a closing?
Yes, Your Honor. Again, my name is Amanda Brockler.
Please proceed.
Avery Becker did not break into 444 South Flower Street. Avery Becker did not kill Mackenzie Brackman. Avery Becker is not guilty. The prosecution brought forth 2 charges in today's case. Let's talk about those charges because you're about to be asked to deliberate on them. First charge, burglary in the second degree. The second one is murder in the first degree. When bringing forth these 2 charges, the prosecution accepts the burden of proof onto themselves, and they have not met their burden. Let's talk about the most fundamental way to meet your burden of proof as the prosecution. The sheer identification of the defendant. That's step numero uno in meeting your burden of proof. None of the 3 prosecution witnesses identified Ms. Becker. That's cause for you to acquit her alone. Let's talk about their case and their lack of evidence. Detective Markowitz got up here and told you on the stand that the one piece of evidence that ties Avery Becker to this crime is the cell phone data records. Detective Markowitz also couldn't tell you when this murder occurred. Look, putting aside the fact that you heard from 3 expert witnesses today that cell phone records are not reliable and do not track the location of a person accurately, they're irrelevant in this case because we don't know when the murder occurred. How can the prosecution hold Avery Becker accountable for her location if they don't know when they're supposed to be placing her at the crime scene? There is no physical evidence to tie Avery Becker to this case. You heard 2 expert witnesses on the prosecution side, both that had access to the crime scene and were able to analyze the crime scene, and they failed to collect any concrete evidence to tie Avery Becker to this case. That's right, no DNA, no blood, no fingerprints, no hair, follicles, no clothing, nothing. There is no identification of Avery Becker at all in this case, and there is nothing tying her to this crime scene. What the prosecution is asking you to do is unreasonable. They're asking you to make a leap from a high school mock trial bit of drama to murder. And they're giving you no evidence to substantiate their claims. That is unreasonable. All in all, this was a rushed investigation. This was a rush to judgment. So members of the jury, this is your job. Make this a rush to justice. Acquit Avery Becker of these crimes. Find Avery Becker not guilty because there is no evidence tying her to these crimes. The burden of proof simply hasn't been met. She wasn't even identified in the courtroom today. Make this a rush to justice. Find her not guilty. And tell the prosecution, tell the police to go back out there and find the actual criminal that is still around, tell them to find them guilty. Look, the prosecution has one last opportunity to come up here and meet their burden of proof. I'm going to tell you right now, they can't do that. They can't answer these fundamental questions. You are left with an unreasonable amount of doubt. You have to find Avery Becker not guilty. Thank you.
And it's my memory that the prosecution had at least requested the reservation of a rebuttal. I haven't kept track of their time. If they have time, do they wish to make a rebuttal closing?
Not at this time, Your Honor.
Okay, thank you. At this point, I'm going to have the case is going to stand submitted to the jury. I want to take just, because I'm the only person on my screen, I want to take a moment to tell you how absolutely impressed I am. It always amazes me the quality of the people who come in and do mock trials. And I speak from some serious experience. I've been trying cases for 30 years. I taught trial advocacy for 10 years. I've sat mock trial time and time again. And all of you were spectacular. And I'm not just saying that to buff you up and push you guys out the door. It really impresses me on where you're going. I'm going to give Allie a second here so she can make a determination of how she wants to go forward with comments from the scorers, or if she wants me to go forward with comments for the individual participants, or if she's going to tell us all to go home. So Allie, it's your call.
Awesome job, everyone. This was such a great round. So at this point, we'll have the scoring panelists finish up on their scorecards. And scoring panelists, once you've finished, shoot me a quick message and let me know. And then once I've received notifications that all of the scores are in, that's when we can start some comments.
Okay, so I get to keep talking. Aren't we all happy about that?
Yes. Do you have some wise words of wisdom to offer?
No, but I actually, one is, I went through it. As we approached the opening, I think it was Ms. Bensley did the opening for the people. And I mean, it's probably childish of me. I really like the way she said, our story begins, which is just a reminder of the fact that the only way you're going to get from point A to point B with a jury or a judge is to tell them a story, or they're just going to wander off and go elsewhere. I thought that was really nice. Mr. Aragon did the opening for the people, and I really got from him the sense, and I think I actually used the words, and one of the objections was this question of a rush to judgment. And so if in fact he said those words, and I'm going to assume that he did, that I really like the way that it was echoed by Ms. I'm sorry, is it Bauschler? Brockler, I apologize. I'm not good with names. I really like the way that was tied in at the beginning and the end. The first witness was conducted by Ms. King, and I really like the way that she did laid the foundation to have the expert witness come in, and the way that she managed her witness and had him tell what the story is. Mr. Aragon did the cross on that. And it's the first time I wrote it, but I think I wrote it for everybody's cross, which is they were uniformly leading. I remember a couple of open-ended questions and people were promptly beaten about the head when they did do an open question, but that was the first time I really noticed the facts that it was so leading. I really liked the 703 objection. I was really struggling with that, and I thought that it was probably well taken. But such is life. Take me up to the Court of Appeals. The next witness was, the direct was by Ms. Bensley. Am I saying that name correctly? I really like the way, of all of the witnesses, you had very open-ended questions. You really gave your witness the opportunity to shine through and to present their story as you did it. There's nothing that you did during the course of that examination that operated to close down or to prevent a specific area of response. And then the one compliment I'll give you, which I mean wholeheartedly, and I personally struggle with, is you listened. I really felt like you had a good listening and a good comprehension of where your witness was going. Mr. DeRose did the cross, and one, nice objections. I really appreciated the fact that he was presenting objections. He was doing it timely. I thought they were mostly well taken. He also, for the first time, said that's a yes. And I know that several people brought that up. I think that's the way I handled the bad witness. And so it was nice to see that somebody was doing it beyond an old man. So I thought that was really good. And those of you who did that, I think it's a good way to slap around a witness on cross-examination. Ms. Wright laid the foundation for, I'm sorry, she did the final witness. It was the officer. I'm sorry, I've forgotten his name. And there's a lesson that she teaches me again about the way to approach laying a foundation for an expert, which is to constantly tie it into the case. And so as she was going through, I really felt like she was taking her expert, tying it into the case, and I could hear the words coming out as she went forward on it. Okay, now I'm sorry, I'm going to miss the name again. It's Brauschler?
Brockler, but you can say whatever you like.
Can I say Amanda?
Amanda's great too.
No, I think that's condescending. So Ms. Brockler, you got one, I was not going to be sustaining anybody's objections, and you got me to sustain on a Fifth Amendment, which I think you were searching for while you were trying to do it. And I give you credit. It'll be interesting to see what the Court of Appeals does with that one on it. I thought that as you approach the cross-examinations, and many of you did this, but I'm calling you out for this one specifically. You guys did topics. Let's turn to, let's talk about, this is what I want to do. As a trial attorney, I don't do topics all the time, and I'm sure the judges are going to tell you that they just get lost. So many times they have no idea of where you're going, and having the topics, even on a cross, gives an indication of where you're going. Thank you for that. I needed that to keep me awake. Oh, great. I get to start with Ms. Brockler. Good. I think I did it right that time. She did the first of the directs for the defendant. And you had a good witness. And I think that you did a good job dancing with a good witness. And so I want to say that. But again, it's this question of, and maybe, I don't know why I'm picking on you for this, the question of topics. One of the things you said was, speaking of assumptions, right? Well, we knew exactly where you were going to go, and then you get to ask the question with it. And it really tied it in. I thought that Ms. King did the cross on this witness. And again, one of the things that she was starting to run into was a witness who was talking too much and giving an answer that really went beyond the scope. And again, as with everybody, I think she did a great job of trying and not necessarily always being successful, of bringing the witness back. And I actually took a little bit of worry about the credibility of the witness after that. Mr. DeRose did the next direct, and you know what my notes say is this, that the questions that you were asking were extraordinarily open. And it's another thing of letting this witness come through and hearing it in the witness's own words. There were a couple of examinations where the directs would fall into a leading question. You guys are great with leading questions, but you know, bonus points to whoever's teaching you how to do them. But you're sometimes doing them on direct. And as an attorney who does that far too much, I will tell you that judges get cranky with me. Mr. Bensley, am I saying that right? I think I am, did the cross, and my comments are leading. Everything that he put into that was a leading question. There was no room, there was no ability for him or for the witness really to wander off. And when the witness did, he brought him back, I thought, very well. And I think this is the one time when there was a significant witness correction. If you say, you know, that's a yes, it always feels to me like that's a fairly mild witness correction. But I remember Mr. Bensley as really kind of calling the witness on cross down to the table, and I thought it was warranted and therefore well taken. We did, the last witness was a direct by Mr. Aragon. And coming back to the theme of the story here, I really noticed on his examination of the way in which he was really letting the witness tell the story. You know, this is a witness who, when they're up on the stand, you have to have them express themselves. It has to be something that the jury is doing. And so I really like the way that the questions were structured on it. Ms. Wright did the cross, and again, the Court of Appeals is going to disagree with my interpretation of the rules of evidence a couple of times there. I really think that, again, this is a situation where she had objections that were well taken. She was appearing in front of an unreasonable judge, perhaps, who wasn't giving her what may have been a different ruling on a different day, but she took it well. She sat down on it and she kept moving forward with it. On her cross-examination, what I noticed, and again, kudos, was the topic. She laid a topic and then she followed up, and she stayed within that topic before she moved on. And so my notes say this, which was a well-formulated question and a well-formulated answer. And if you spend the time to ask a good question, you will actually get a good answer. And I always comment to myself whenever I screw up, because when it's real, you know, when you've asked a bad question and it's 10 minutes later and the judge is looking at you in a bad way. Closing argument was by Ms. King. Am I correct on that?
Yes.
One of the things that I notice when my brethren and I do closing is we babble. We just kind of run through the facts. I really want to comment on the way I felt like your facts, you took the time to tie it into the law. And so you took a second, you told me what the standard was, and you told me how the facts were going to be applying to that standard as you went forward through the case. So kudos on that. Again, as is the case with all of you, you're better than 50% of the people who are making a living doing this. And then Ms. Oh, damn it, Brockler?
Beautiful. Perfected it.
Brockler is good enough. I am, you can even see it here, right? I'm totally handsy. I really like the way that you use your fingers. What we're doing here, and Mr. Aragon, I think, did this in his opening statement. We're in a very limited situation where you're trapped, you're sitting at a chair. Mr. Aragon stood up, he did some purposeful movement to tell us what sections he was working on. But you gave me the one. You said there's 3 reasons, and this is no reason number 1, reason number 2, reason number 3. And for even an idiot like me, it's a nice organization. And by the way, it's a nice prop that's built in. And then I put the comment here because I am convinced, and Mr. Aragon will not correct me, that he used the words rush to judgment in the beginning, and you closed with that. And I thought that was a good close. I am happy to answer any questions that you specifically have of me. You can shout them all out at once or stare into the screen while we wait for Allie to tell us when it's time for us to part our company this evening.
So we are all ready to do some of the scoring panelists' comments. Judge Bailey, thank you so much. Magistrate Yoder, do you want to start us off with a couple minutes of comments?
Sure, let me introduce myself. I'm Bradley Yoder. I was a district court magistrate for 25 years. Retired from that 10 years ago. Now I do mediation and arbitration. I was very impressed by all of you and your efforts. I mean, obviously you worked very hard on this and you deserve to be congratulated on that. I was very impressed with your knowledge of the facts of the case. A few sort of minor things. One, when you are the attorney questioning a witness, don't make statements of your own. If you are in front, if you have an experienced opposing counsel, they're going to object to that. Is counsel testifying, Your Honor? So it's okay to ask leading questions, but you need to put a question, if you're going to make a statement, isn't that correct? Or something like that. One statement of Ms. Brockler that stuck in my mind, it was a very great presentation by you, I thought, but you said that's not the only mistake in this investigation when you were questioning a witness. So, that will generally get attorneys up in arms. And if you get more into the competition, further into it, you may end up with that kind of an objection. So be careful. Leading is great. Testifying is not so great if you're the attorney. Just a technical thing, and I'm sure you're aware of this, it was hard to hear Ms. Wright. I did hear you, I think, most of the time. And I noticed that, your microphone had the slash through it. So I kept thinking, oh, can you unmute that? But even when you were not muted, your voice was quite soft. And I don't know if you can correct that technically, for later rounds, but I think that would help. I don't know if it's getting closer to the microphone or using different equipment or having somebody do a test on it, but that probably would be helpful. In doing these, it's helpful not to talk in a monotone. You'll lose your listeners. If you could be personable about things, do it more conversationally as opposed to da-da, 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 da-da. You don't want to bore the people that you're trying to get to listen to you. So try to be more conversational. Some are better than others, but generally, if you can be personable, you're going to have a better audience as far as how your presentation is received. So those are just some minor things, but I like the leading questions on cross-examination. I like the fact that there weren't a lot of interruptions. When witnesses are trying to testify, they were allowed to answer. Sometimes, if you're doing cross-examination and the witness is not answering your question, it's okay to break in. But I thought you were all quite professional and polite in that regard. So those are some of my comments. But again, kudos to all of you. I know this isn't easy. It's very nerve-wracking. You have to concentrate on what you're doing technically. And it's like, oh, can I be a human being at the same time? That's a difficult thing to do. The best lawyers will get to the point where they can do that. And so hopefully you'll continue on in legal careers and become great lawyers.
Great. Thank you so much, Magistrate Yoder. And Ms. Busby, do you want to go next?
Sure. Hi, everyone. My name is Ariana Busby. I'm a litigation attorney at Hall & Evans, which is a law firm downtown. I don't have a ton to add. You guys have gotten some really great feedback already, so I'm not going to keep you guys here all night. But really, really fantastic job. I really want to commend you guys on everything that you guys were able to put together tonight. I know how difficult it is to do this in a virtual environment. You guys really powered through anytime you had a tech issue. Kitty, way to go with just resorting to that chat box when you were having issues there. Really good, quick thinking there. Especially, you're on a time clock. And so just immediately resorting to the chat box, I thought that was brilliant. I judged Arapahoe County last week and we came up with a million tech issues and I didn't see anybody think to do that. So I really just thought that was brilliant. But everyone just did an amazing job. I would have never had the guts to do this when I was in high school. So I'm just really proud of you guys. Good work. And I wish you all the best of luck in the next rounds.
Okay, and Ms. Picker.
Hi, I'm Cassie Picar. I also am a litigation attorney with Ms. Busby at Hall & Evans. Go Hall & Evans. Just to touch on high notes, because everybody else is already hit just about everything I would have already covered. I thought openings were really good. There was a both of you all did a great job of setting a roadmap for how the case was going to go. And I thought that was a great tone by everybody, good flow, just setting up the case and being able to let us know what we're going to see throughout the course of the trial. So great job on openings. Just general comments on direct and cross. If you are, as a witness, when you're getting asked questions, if you need clarification, or a couple of you asked for clarification, but a couple of times, and I think Magistrate Yoder brought it up, is if they ask you kind of questions that don't have it, is that correct? Or is that a yes? Is that a no? Don't be afraid to say, is that a question, back to the attorney, because you shouldn't be required to answer those kind of just hanging non-questions. On cross, I thought everybody did a really good job on cross as well. The only thing, be careful if you're actually conducting the cross, because I felt a couple times you kind of threw out some softball questions on cross that could potentially get you in trouble long term, just because unless you know what the answer is going to be, tread lightly in the cross realm. I thought everybody was just presented very well, great professionalism all around. I really thought one person that really stuck out to me was Miss Patel. I thought she made a really good witness, I can't remember which of the judges commented on it, but she was just very personable, likable. I was really kind of, I guess, into her testimony just because she was not the monotone that kind of you can kind of get stuck in when you're doing this for so long. So other than that, great job, everybody. Just, fantastic all around. Like Miss Busby, I would not have done this in high school either. So it takes a lot of guts and hard work to do this. So good luck advancing, and I wish you all the best of luck.
Awesome. Thank you so much. Thank you so much to our scoring panelists and Judge Bailey. We could not do this without you, and we so appreciate your time today. And awesome job to all the participants. Get some sleep tonight, and we will see you bright and early tomorrow.
Thank you.
Thank you all. Great job.
Thank you.